There's also some issues with imposing new contracts on people. Of course, there has to be consideration. There's some logistical considerations with that as well, and given the background of the employment relationship, has to be taken into account. So I would advise to seek legal advice if you're trying to impose new contracts on people. All right, so employment standards. So the Employment Standards Act 2000, which apparently is 18 years old, doesn't seem like it, sets minimum standards for employment in Ontario. Vacation, overtime, stat holidays, that sort of thing. So I just focused on 3 areas that I thought law firms might be concerned with. One is overtime, one's vacation, and then leaves of absence. So overtime. This may come as a shock to the lawyers in the room, but overtime is required for most employees after 44 hours in a week. There are some exceptions, including for lawyers. Sorry, those of you who are associates. But not for legal assistants. There's no exception for them, right? Overtime must be compensated at time and a half. And for those of you who aren't grizzled, union reps or HR people, time and a half means you pay 150% of their regular rate for those hours. Okay? It can be compensated with lieu time, paid lieu time off at a later date, but there's some conditions on that. One, the employee must be agreed to be compensated with lieu time instead of money. And that's one of the things you could get them to agree to in the contract from the outset. The lieu time still accrues at time and a half, 1.5 times the time worked. So if they worked a 45th hour, they've picked up an hour and a half of lieu time to be used later. And that lieu time has to be taken within 3 months of the week they work that overtime, or if they agree, you can stretch it out to 12 months.